Good morning, everyone. I know some people are still in the process of signing on, but I want to take this moment to welcome everyone to our May 2024 edition of the Morning Blend. I'm Alison DiFlorio, co-founder and managing partner of Exude Human Capital. And for those of you who've been with us before, you know that our partner on these Morning Blend webinars is our good Lori Armstrong Halber from Fox Rothschild. Good morning, Lori.
Good morning, Alison. How are you?
I'm doing great. Always great to see you.
You as well.
You know, Lori and I were just talking when we set the date for this particular episode or this webinar. We were thinking about what's coming, what's happening, what are the decisions, what actions do employers need to take, and honestly, there were a few things, some of which were in our little flyer about the webinar. And as soon as we set the date, it seemed as though the universe opened, and so did decisions from the EEOC and the FTC and the Department of Labor. And so we've adjusted some of the content today to make sure that we're bringing to you the most updated legal updates and focusing on what HR needs to do now in order to respond to some of those. So if it deviates a little bit from what we had said we were going to talk about, there's a reason why. For those of you who have joined us before, welcome back. For those of you that are joining for the first time, welcome. Just a reminder for everyone, your phones will be muted for today's presentation. However, your questions are really important to us. So if you have any questions, please feel free to pop them in the QA and we will do our best to address them. If we're not able to do that, then we will, our contact information is at the end, and we are always available to you for further discussion on any of the things we speak about today. We will also be sending out a link to the recording of today's webinar. So please feel free to share this with individuals who may not have been able to attend today or members of your team for whom you think today's content would be of value. So that said, I think we should go ahead and share a little bit about who we are and what we do as it relates to today's content. For some of you, you may know that at Exude Human Capital, we are a full-service human resources consulting firm with expertise in the areas of human resources, diversity, equity, inclusion, and belongingness, and leadership development. And we really believe, and I think you'll hear it today as well, that it's you have to pay attention to all three of those levers in order to build the appropriate structures, policies through that lens of inclusion and equity, and then develop your leaders to execute effectively on those, to have the impact that you want to have. In particular, in today, some of the things we'll talk about is how what you hear today relates to some of the work we've been doing in the job architecture, job design, and compensation space, as well as policy development. And Lori, thank you again for just being such a great partner on these. You want to share a little bit about the firm and your work?
Yeah, thank you, Alison. I'm so thankful for our partnership. Gosh, it's been years now. And so my personal background, I have been practicing in the space of workplace law for almost 30 years. I have done everything from counseling to jury trials to traditional labor. I practiced before state and federal agencies and really try to assist employers with every aspect of workplace law, both from a compliance standpoint, but also from a practical business approach. And as a part of my practice, excuse me, I do a fair amount of training of supervisors and employees on workplace culture and things that I know we've partnered. In fact, that's how we met, Alison, doing a training together. I have a little tickle today, so sorry. In my spare time, I corrupt young legal minds as an adjunct professor at Temple Law School, and I am also an EEOC mediator in their ADR program. And then, for fun, I walk my huskies and hang out at the beach. But at Fox Rothschild, however, is a full-service firm. We are really all over the U.S. and have a really diverse area of practice, in addition to labor and employment, which is one of our strongest practice groups. We do everything from corporate commercial litigation to corporate formation to domestic relations and family law, trust and estates law. So, we're equipped to help with pretty much any problem that you might have, both personally or professionally. So, and
Great.
we really are thankful for our partnership with Exude. I think that having this opportunity for folks to hear sort of the technical legal side, but then really what does that mean and what do we do with that is so important.
Great. All right. So let's get into it. There was almost not enough space on the page to list the topic for piping hot, but we're going to talk about some SCOTUS decisions around job transfers as adverse actions, some updates from the FTC on non-competes, of course, the DOL independent contractor test, and the FLSA salary threshold, which is just right around the corner. As well as the EEOC pregnancy regulations and harassment guidelines. And then for our daily brew, we're going to talk about some of the steps that you can be taking as HR professionals to prepare your organizations to be ready for these changes. So Lori, with that, I'm going to turn it over to you to kick off our conversation.
All right. Well, Alison's right. Literally, we try to do these, I think, every other month or at least quarterly. Yeah. And we send out our little placeholders so you all can put it on your calendar. And with that, the last 2 weeks of April, the proverbial, hit the proverbial fan. All of these things came out and there's so much to talk about. So the first segment here, we're going to really talk about from the legal compliance standpoint, and then we'll spend most of our time talking about, well, what does that mean for you? So one of the big employment decisions that came out this year so far is the Muldrow versus City of St. Louis, Missouri decision that came out in April. Now, one of the reasons I like this area of law is because it's constantly changing. I'm not much sure my students appreciate this, but when I'm teaching, I usually make an exam question, some pending Supreme Court decision, and ask them to predict what's going to happen. The facts of this case, I think, are sort of justify the holding. But when I tell you that the decision was unanimous, that might be a little surprising because we hear all the time about how divided this court is. So in this particular case, the plaintiff was a woman, Jatanya Claiborne Muldrow, who had worked as a plainclothes officer in a specialized intelligence division. So fairly prestigious position within the police organization. A new supervisor came in and replaced her with a male officer because he felt that the officer was a, quote, better fit for the dangerous work that the division handled. And he transferred her to a uniformed job. Now, there was no impact on her rank or pay. So basically, same title, same rank, same pay, you're just doing something different in a different division. The responsibilities, perks, and work schedule did change as a result of that transfer. Now, I will tell you historically, defense counsel, folks like me who are defending employers, would have argued that because neither the pay nor the rank nor any of the real, what we would have called material terms of her employment had changed, that was not what we call an adverse action. And therefore, it's not a violation of the law to make that change. The court in this case held that an employee bringing a claim for discrimination under Title VII that relates to a job transfer doesn't have to show that a significant disadvantage or a material change, just some employment disadvantage that results from the transfer. And in this case, a loss of prestige, a loss of responsibility, it might have impacted her ability for promotion and things like that. This is a big deal for a couple of reasons. One, it is a unanimous decision, which again is somewhat unusual, and particularly with today's court, but means that everybody's on the same page, that a change in somebody's job, even division, not title and pay, can be enough to be an adverse action. And it does not, although this decision was decided under Title VII, it's going to apply to pretty much any of the employment discrimination laws. So this is, kind of a big deal. And I think we're going to talk a little bit more later about the ramifications, but what I will say on the short end is if you are contemplating moving people around, take a moment, call your labor and employment lawyer. If you don't have one, call me. And if I can't help you, I will find somebody who can. but just to make sure that you've evaluated the risks before you make those moves.
Okay, great.
And the hits kept coming in April. The FTC at the end of April announced that effective September 4th, it was going to enforce its rule that banned most non-compete agreements. 30 million workers are currently subject to non-competes. It's kind of an interesting thing. I mean, the idea that the FTC is not the only agency out there that is looking at this. The National Labor Relations Board, by the way, the one thing we're not going to talk about today is the NLRA and the NLRB, except for this little brief shout out, that they are also concerned. The idea being that the restriction on employees from moving jobs has an impact in many ways, including on competition, including on allowing employees to assert protected concerted activity, i.e., kind of think of it as an individual strike. If you're not paying me enough, I should have the ability to move and find someone who will. A non-compete doesn't allow me to do that. Things like equitable pay, whether we're talking about gender equity or other things. So they're kind of disfavored on a lot of fronts right now. And including, just as a stat, as of last year, there were 73 bills in 27 states and 5 others in Congress addressing non-competes. So this is kind of a hot area. The rule that the FTC says they're going to enforce is going to, as I said, restrict all non-competes except for 3 exceptions. If you have a senior executive who entered into one before the rule takes effect, you can enforce that. If it's part of a buyer-seller transaction as part of a bona fide sale, so I'm selling my family business to somebody else, there can be a restriction on me to like go and open a new competing business, or as part of a franchisee-franchisor relationship. The rule also is going to require that employers notify employees, including independent, I said employees, but I mean workers, including independent contractors and employees, that if you have such an agreement, it's no longer valid or enforceable. There are, however, court challenges. There are 2 lawsuits that are filed in federal courts in Texas and 1 in the federal court in Pennsylvania. We don't know how they're going to shake out. But so this is not necessarily a done deal, but I would expect there to be ongoing restrictions on non-competes generally. And this is not something we're going to talk about later. So I'm just going to take a minute to say, you should be thoughtful about why you were using them anyway. What are you trying to protect? A lot of people sort of do it sort of thinking, well, I need to have one, without really going through the analysis of what it is that you're concerned about, because there are other ways to concern, for example, proprietary or trade secret information. Like, even if I can't have a non-compete, if I work for Coca-Cola, the formula for Coke is a trade secret. I can't steal the formula for Coke and use it elsewhere, because there are other protections that are in place. So just again, if you have non-competes, or if you use non-solicitation clauses or other sorts of restrictive covenants, again, touch base with your legal counsel. Ask them, do I need this? Why do I need this? What would be a better way to protect the things that I'm interested in protecting?
Okay, great. And I know that I have seen a number of them that seemed pretty restrictive in terms of the length of time, and started to see people pulling back on the length of time of non-competes over the years too. So
yeah, I mean, it used to be in Pennsylvania, for example, that generally 1 year and within a reasonable geography was acceptable. I mean, I think the remote model, to the extent non-competes are enforceable at this point, they really have to be tailored to truly competitive situations and truly, proprietary, confidential trade secret information, which is more narrow than most people realize.
Right. So add it to your list, everyone listening. You've got to review those, or get ready to review those, pending whatever these decisions or challenges, however they pan out.
I feel like every slide's like, call your lawyer at this
I
point.
know.
Because also on April 24th.
Or review and update. So what's happening with the U.S. Department of Labor?
The Department of Labor had a lot going on, both in April and earlier this year. So since we didn't talk about the earlier thing, I will touch on that after this. But on April 24th, it issued the final rule regarding salary thresholds. You may recall during the Obama administration was the first sort of real change we saw in the salary thresholds. A couple things I want to say, just as a reminder. Salary does not necessarily mean exempt. A lot of people think I pay them a salary and I don't have to worry about overtime. That's not how it works. The default is that if an employee is working for you and they work more than 40 hours in a week, they are entitled to overtime, unless they fall into one of the exemptions. The exemptions are specifically defined, and a number of what we used to call, or we call the white collar exemptions, are those that include as one of the requirements that you pay on a salary basis, meaning the person gets paid the same amount every week, regardless of the quantity or quality of work. And then there are other things that you have to check off as well to fall within those exemptions. So these regulations deal with those exemptions, and what they're doing is raising the dollar amount for the salary threshold. So it's not just that you pay them that salary, you have to pay them at least currently $684 a week or $35,568 a year. That is going to raise to $43,888 effective July 1st, and then bump again to $58,656 a year effective January 1st. They are also increasing the highly compensated exemption. Those are folks that if they make over a certain amount, it's sort of presumptive that they're going to be exempt because you're paying them so much, you can work them all the time if you want. Those thresholds are going to increase from 107,432 to 132,964 on July 1st. And then again in January to 151,164, which is a 50% increase. So these are pretty substantial increases. You may recall during the Obama administration that the Department of Labor did something similar. Those were challenged, they were enjoined, but then in fact, there was an increase. It was just a lower increase. Again, the absent there being a Supreme Court decision on agency authority, which is out there sort of pending, you can expect that there will be an increase. It may in fact be the increase that the DOL has issued. But even if there is a challenge to the amounts, there will be some adjustment to the salary threshold. The other thing that these rules include is an automatic update every 3 years, beginning on July 1st, 2027, so that I guess they don't have to keep doing this. The idea is that there would be an automatic adjustment to coincide with, adjustments in cost of living and wages and things like that. So I know we are going to talk about later what this means for you.
Mm-hmm. Lori, is it fair to say though, because when this happened the last time, I know that a lot of the organizations that we've worked with, we're looking at their compensation, we're looking at some of their salary, their exempt, the existing classified exempt employees and doing the calculation and the math as to whether it would make sense to do some increases to hit the salary threshold. But is it correct to say that that's only just one of the tests, that they also have to be able to meet the other criteria for exempt status?
Yes. Yeah. So just because you pay somebody $43,888 a week effective July 1st does not necessarily mean that they meet the other requirements for the exemption, which typically include, like for the supervisory exemption, that they supervise as their primary job duty 2 or more employees, that they exercise independent discretion and judgment on behalf of the employer. So there are other criteria, you're correct, that have to be satisfied for the exemption to take place.
Right.
And you can go ahead.
We will talk a little bit more about that later, but I just want to make sure everybody who's on, you're not just making a financial adjustment here and satisfying something. There's more to it than that.
All right. And the U.S. Department of Labor was busy also, effective in March, revamping their independent contractor rule. The independent contractor rule that they issued adopts a 6-factor test. Now, I want to say this because we spend some time talking about, is somebody an employee versus an independent contractor? It is a hot topic among a number of agencies. I will give a second shout out to the NLRB because that act doesn't cover independent contractors, although they think it should. So the test for whether somebody's an independent contractor they have is a little different from this. The IRS has a test that's a little different from this. So this only applies to whether or not an employee is covered by the Fair Labor Standards Act and therefore is eligible for minimum wage and overtime pay as set forth in that statute. So under this test, a worker could qualify as an independent contractor and not be subject to the wage and hour requirements of the Fair Labor Standards Act if they have an opportunity for profit or loss depending on their managerial skill, if they have investments by the worker, the relative investments by the worker and the potential employer, the degree of permanence of the work relationship. So if you hire a lot of people do this, we're going to hire a temp and then they're working for your company for like 6 years. They may actually be your employee at that point. The nature and degree of control, the extent to which the work performed is an integral part of the potential employer's business, and the skill and initiative. So one of the examples I give typically is if I hire somebody to paint my house, that's not my regular business, right? I need somebody to come in and do a specific task for me. They're typically going to have the tools. I might supply the paint. I might tell them what color certainly in every given room, but the expectation is they're going to do the job or the task that's assigned. Now, if I hire Alison's painting to do it, Alison may hire individual painters to come with her. She's going to tell them what time to show up, where they're going to be painting. She's going to pay them most likely on some sort of hourly basis, or, well, she should pay them on an hourly basis because those folks are going to be her employees. And so it gets a little more complicated when we're talking about an organization, but you sort of think about if this is somebody, if I weren't using a contractor or a temp, this is somebody I would have somebody regularly doing, that person's probably an employee. And the test, just so you know, the list is not exhaustive. They're really going to look at the totality of the circumstances, the economic reality approach, look at other relevant factors, which in some way indicate whether the worker is either in business for themselves and then truly a contractor or really doing work for you. And it's like, if it walks like a duck and talks like a duck and you try to call it a goose, it's still a duck. So again, if you have folks that you're considering independent contractors, and this is going to go great in our conversation in a few minutes, but it's an opportunity for you to consult with your counsel, have them do a review, and highlight if there are any issues. Because I will say, the stat from 2 years ago, the top 10 plaintiffs' wage and hour class action suits averaged $45 million per suit. And we kind of think like it's only a few dollars here and there. But if you're underpaying somebody $10 a day, 5 days a week, then it's $50 a week. Then it's, $2,500, which doesn't sound that bad until you've got to do it for 3 years and you have to double it because that's what the statute provides for. And then you have to multiply it by every employee. And then you have to pay their lawyer's fees. So wage and hour issues start out really small and exponentially increase very quickly.
I think everybody just got, kind of a little wave of,
don't panic. We're here for you.
Exactly.
All right. And then our last federal agent. So these are all federal agencies that we're talking about. Don't forget that your state or local agency might also have stuff that's going on. We don't have time to kind of go through every potential issue. I normally highlight New York, New Jersey, Pennsylvania if there's something really hot, but these are the federal agencies. So they cover on average anybody who employs 15 or more employees. There are some distinctions, but so the EEOC, which is the agency that enforces most of the anti-discrimination statutes, issued the Pregnancy Workers Fairness Act regulations on April 15th. So April, again, the hits were coming. These are supposed to take effect on June 18th, 2024. As you may recall, the act was passed in 2023, and it is a supplement to Title VII and the Pregnancy Discrimination Act that essentially now requires employers to provide reasonable accommodation for pregnant workers. The idea being that, if someone is pregnant, we want to facilitate their ability to keep working if they're going to need to take some time off for their own care or for related pregnancy related issues. That's fine. The idea being that we want to encourage people to be engaged in the workforce, and we don't want a temporary situation to negatively impact that ability. So that's the policy behind these types of statutes and the regs. In this particular case, there are some, I'm just highlighting a few of them. There are some issues that have come up, and I'll be curious to see the challenges to the regs. The first one is not, totally crazy to me. It prohibits employers from requiring an employee to accept an accommodation other than one arrived at through the interactive process, and from requiring a qualified employee to take leave if another reasonable accommodation can be provided. This is different from the ADA, because the case law generally under the ADA is the employer gets to pick. As long as you provide a reasonable accommodation, you've done your job. In this case, there is a higher burden to engage in that interactive process, and you can't just say, fine, you're pregnant, you can't work, you have to take leave. We have to look at things like light duty, modified schedules, and really explore, other solutions that would enable a pregnant person to continue working. The biggest area of challenge is the related medical condition area. The EEOC has broadly defined the scope to include pregnancy, non-pregnancy, miscarriage, infertility, fertility treatments, abortion care, birth, pretty much anything that is associated with pregnancy or women's reproductive rights. Or the EEOC includes them as a related medical condition. There is certainly an uproar about some of the categories that are included that I'm sure are going to be subject to challenge. Again, typically an agency has deference to interpret the statute as long as the interpretation is not broader than what Congress wrote. But, we'll see. This is another one of those. There may be some tweaks to these regs as we go forward. Just another distinction from the ADA, the PWFA provides that an employee can meet the definition of a qualified worker, even if they can't perform one or more essential functions, because, or the reg says, provided the inability is temporary. But again, the idea is that the person who can't do this can't do it for at most 40 weeks. And then they should be able to do whatever that thing is thereafter. And again, the policy reasoning behind it is it shouldn't be that difficult to accommodate somebody on a short-term basis, to allow them then to come back and be fully functioning participant in your workforce.
Right. And I want to say there's something going on right now, and I think the city of Camden, related not necessarily to this, because this goes into effect June 18th, but something with regards to an accommodation for pregnancy. That's kind of interesting. Somebody being denied work from home for a related condition. So
I have to look up, I haven't looked that up, but that doesn't surprise me. Work from home, we could do a whole subject on litigation for work from home.
I know.
There are a couple other key points. Let me cover real quick. On the next slide, on the pregnancy thing. So some things are presumptively reasonable, things like restroom breaks, food and drink breaks, allowing water nearby, sitting or standing as necessary. Those things are presumptively reasonable. So you should assume that you have to provide those accommodations. There are certain areas where you can't seek documentation, which feels counterintuitive, but the idea being that we don't want employers to be super nitpicky about stuff. So if it's obvious and, reasonable, then you shouldn't be saying, somebody's clearly 8 months pregnant and says, I need a restroom break. Oh, we need a doctor's note. Under the ADA, typically we require a lot of documentation. That's a longer term situation. again, you'll see the regs say that employers have to respond to these requests with expediency. It's a short-term situation, and we want to make it easy for people to be able to continue to be employed while they're pregnant. There may, however, be some overlap with the ADA. So again, if you have somebody who has, for example, maybe preeclampsia or some other condition that is impacted by pregnancy, you might have both the Pregnancy Worker Fairness Act considerations and ADA considerations. So my mantra for today, call your lawyer, and get comfortable with some of these things. And please don't hesitate, to reach out to get some support around these things. I think this is a little bit complicated, and when it's new, it's very easy to make a mistake, even innocently.
Lori, we have one question, and I believe it's related to this. What happens if the position is unique and no one else can fill in?
So this would go through that undue hardship analysis, and you'd have to really be able to establish, but ultimately it might be that you'd have to grant leave. I mean, you have a lot of other issues as well. If we're talking about somebody, let's say you're a large enough employee that you're covered by the FMLA, person goes out on pregnancy, they get that job back unless they satisfy a key employee position. You have to hold that job for that person anyway. If you're not covered by the FMLA, that's not a consideration. So I guess what I'm saying is it depends. There is certainly a recognition by the law that there are situations that really can't be accommodated, but that should not be the default.
Okay, great.
All right. And the EEOC at the very end of April, our last flaming hot, just off the presses, was the EEOC's issuance of their workplace harassment guidance, which is effective immediately. And I'm actually happy about this because I don't know if any of you spend any time on the EEOC website. And I will say, I think the EEOC is one of the most helpful agencies in providing FAQs. DOL is pretty good too. FAQs and guidance and examples of things that they view as, violative of the law and what have you. But they've had a number of different FAQs and guidance related to harassment. They now put it all together and they've updated it, particularly since the Bostock decision, which recognized that sex under Title VII includes gender identity and sexual orientation. So just a couple of highlights. And man, it's like if you are scrolling around or Googling, you're going to see articles from all sorts of law firms, including ours, summarizing them. And there's a lot of stuff. So these are just quick and dirty. Race and color. Color has always been separately protected, but there's a discussion in here about, it's not okay to discriminate against somebody who's a light-skinned Black person by way of example. That is a cause of action in and of itself. So there are some other examples and discussion around what that means. There's discussions regarding pregnancy, childbirth, or related medical conditions. That harassment based on these conditions can include things such as lactation, using or not using contraception, deciding or not deciding to have an abortion, if that harassment is linked to the targeted individual's sex. So when we're talking about harassment training, we're really talking about maybe broader than what you might have done in the past in terms of training. Similarly, sexual orientation and gender identity is specifically addressed under these guidelines. It prohibits conduct such as outing. And if anybody doesn't know what that means, it's telling other people about somebody's sexual orientation really without their permission. The repeated and intentional use of a name or pronoun that's inconsistent with the individual's known gender identity, misgendering. Yes, I understand that there are errors, and I understand that this becomes an area of frustration sometimes for employers. But you need to be aware that we're trying to cultivate a respectful workplace. You need to be thoughtful, and at least make the effort, and you have to have your employees understand that that's required. Denial of access to a bathroom or other sex segregated facility consistent with the individual's gender identity is considered a form of harassment under these guidelines. And then there are,
oh, no, go ahead.
No, go ahead.
No, I was just going to say, we have seen, just anecdotally, a big uptick in request for training around gender identity and use of pronouns, and just from a proactive standpoint in creating a more inclusive environment. But it certainly makes sense to your point about, people may not know, they may misspeak, but you want to be sure as an employer you're doing whatever you can to educate your employees and to protect your organization.
Yeah, for sure. And so last little bit of the piping hot, a few more points from the workplace harassment guidance. Retaliatory harassment. So this is somebody's made a complaint or participated in an investigation into a complaint of discrimination or harassment, and then people start engaging in harassing conduct against those people. That conduct, according to the EEOC, need not be severe or pervasive. That is a lower standard than proving harassment on its face. It just needs to be something that might deter a reasonable person from engaging in protected activity. Now, the legal geeks in the room might be like, wow, that's a change of the law. And it kind of is, but it isn't. The Supreme Court, well, several years ago, recognized that the threshold for a claim of retaliation is lower, because the idea is that we do not want to chill people's rights under the statute. And so while we might require severe and pervasive conduct for harassment, it is consistent that we need only show some sort of negative impact, something that would reasonably deter somebody from raising such claims or from participating in investigation under this section. Again, might be challenged, but to me, it's consistent with existing Supreme Court precedent. The other two areas that are sort of you should spend some time in are the intra-class and intersectional harassment. These deal with things like same-class harassment. So for Age Discrimination Employment Act, if I'm over 40, anybody over 40 is protected under that statute. But a 42-year-old harassing a 60-year-old, over age, can still be a cause of action, even though we're both over 40. So that's what the intra-class harassment talks about, or women harassing women, or men harassing men, something like that, showing a clear intimidation, hostility, what have you, to someone, even though they're within your same class. And then the other is intersectional harassment. So for example, someone who targets older women, makes fun of women in menopause, things like that. That's both gender and age. And so the regs talk a lot about intersectionality and how that works, and that's also protected. And then lastly, it outlines the minimum features of an effective anti-harassment policy, a complaint process, and anti-harassment training. We are going to talk about this in a few minutes, but it is time to revamp your training. At the end of the day, at the very least, you're going to have to incorporate all of these new categories. They're not new, but the guidance that the EEOC has given you gives you a great opportunity to revamp your existing harassment policies and procedures. Whew. Okay.
Whew. All right.
That's Alison.
Did you strap on your seatbelts? There's something that we talked about. I know we're going to talk about it in a little bit, but I just thought it was interesting in prep. You mentioned that there's been such a big swing in training around anti-harassment to be more virtual or video based, or log in. And you were saying how important it is to do in-person training to allow for conversations around some of the more nuanced situations that you just can't always capture on a question online. Can you talk a little bit about that?
Yeah, so there's a lot of studies, and I love doing training, so I'm always fascinated by this just personally. I think this is a very interesting area. And the vast majority of studies demonstrate that most harassment training is ineffective. And in fact, if done wrong, results in a backlash that, I'll just use men and women because it's simpler. But, if you have a male dominated workplace and you're doing anti-harassment training, the men will be like, oh, we got to do this for the women, that kind of thing. Mm-hmm. Video and other sort of static training, people, come on, I bet if you were honest, if you've had to do it, you click the thing when you're supposed to, but you're doing something else, right? So really, it's a cultural question, I think. If you really believe that these things are important, then your training should be part of your regular routine It should be infused, and it should be in person, and it should be participatory, because people remember far more by experience and feel that sensation of, oh crap, I did that wrong, stays with you much longer than sort of the passive auditory or visual learning.
Mm-hmm. And having conducted a fair amount of anti-harassment training in my lifetime, I would agree. And when you see the aha moments on participants where they're realizing, oh yeah, that could have been me. I could have said that. I could have done that. It's a very powerful lesson for people. So great. Well, all right. So, oh, and I'm sorry, I didn't go to that slide. Anything else on this slide you want to talk about, Lori? Oh, you're muted.
Sorry, I didn't know I needed. No, I think that's everything. I think we're on to what should HR
Okay, so
do?
what the heck do we do now? So clearly there's a theme here of updating, revising, reimagining, but we're going to pick a few areas that we think are pertinent, and we're seeing organizations spend a little bit more time. We're going to talk a little bit about job design and job descriptions. And this, Lori, I don't know, but is it fair to say behind any wage and hour claim, there's probably a job description looking to be reviewed as part of the process? Or
this area, I will tell you, we were talking about this before. This fits a bunch of the different things we were talking about: classification, wage and hour assessment,
accommodations.
I mean, really, I think oftentimes employers sort of throw together the job description when it can be crucial. And I think you should share your little anecdote with our friend from the DOL.
Just interestingly, we were presenting at a Philly SHRM conference recently, and an individual shared at a certain point during the presentation, just saying, we were focusing on how important it is to really be able to design, to have a job architecture that you can speak to, and very importantly, have job descriptions that accurately reflect the work that is being done before you can even begin to do a market survey on benchmarking jobs. And this individual shared that, we wish employers would invest the time and the energy to really go back and build that infrastructure, because we just want to know, where did you come up with those? How did you make those decisions? How did you make those decisions about pay? Where does it say that? And is it consistent, and is it well thought out? So note to everybody on the call, yes, sometimes thinking about updating job descriptions and doing that exercise can feel like a monumental task when you're tasked with many other things, but it really does help you be in a better defensible position for decisions around salaries and promotions and movement and accommodations and all of the things that we're talking about, classifications, all the things we're talking about today. We're also going to talk about revamping and re-implementing your anti-harassment processes and training. And then I don't think we're going to talk about this because we may not have time, but Lori already spoke about the restricted covenants, but maybe you can add some color to that if we have time as well. So in addition to those hard facts about why it's important to have a good job design and good job descriptions, we're hearing it on the other side in the spirit of transparency that job seekers, candidates, those in roles feel that it's important to be very clear about the job that they're applying for. And if you look at this data, which is from a recent survey as Simply Hired did, 72% of hiring managers say that they do provide clear job descriptions, but yet 36% of candidates feel that that's really the experience that they're having. And sometimes they're looking at a job posting and then they get in to do the job and they're seeing the job description and it's so different that it doesn't make sense. But I think this is interesting. More than half of job seekers say that the job description is extremely influential in their decision to apply for a job. We know from some of the work we do, even the language you use in a job description can be influential in whether or not someone sees themselves doing that role. And then we have 96% of job seekers say that it's important to work for a company that embraces transparency. And many employers say that they only review job descriptions on an ad hoc basis. There's another study that shows that just under 50% of employers can say with certainty that their job descriptions today accurately reflect what the individuals in those jobs are actually doing. And again, I'll say that we see that when we're doing our compensation work. That's one of the first things we ask about is, how recently have you updated job descriptions? And sometimes we get little embarrassed looks, and that's okay, no judgment there. But it's often because people haven't had time to do it. But it really impacts all of these areas: FLSA, classification, transparency. Can also help you identify opportunities to reduce burnout in some jobs that over time, and I know someone listening out there probably knows this is happening in your organization, a job just grows because the individual in that job brought to it certain skills. So the job itself expands to a point where perhaps that unicorn or superstar may get burned out from acquiring all of these other duties. And then if you're going to replace that individual, are you going to find anybody that can do everything that they can do? So there are a multitude of reasons why this is really important work. I do want to clarify the difference between kind of job descriptions and job design. And for HR people on the phone, this is just a recap for all of you, but we are seeing organizations, especially since COVID, and even in the last 2 years, where there's been even more of a push to bring people back to work, and organizations have looked at their job design. What structure do we really need to support the work that we're doing? And how is it organized so that duties are spread out evenly, that there's clear a clear kind of mapping of where we can collaborate, where we coordinate with other roles. And we have found that in doing this work, you really increase employee satisfaction and motivation because jobs are balanced. They're not, you don't have one job holding all the basket of all the eggs. There's increased productivity and efficiency because when there is clarity as to how roles work together, then people can understand how their role may overlap with someone else. And it reduces turnover and absenteeism, which in all the studies has shown that there's high levels of burnout, there's high levels of stress. We know that for a multitude of reasons, but much of it can be attributed to how jobs are designed. So job architecture, job design really matters. Now, we're going to talk specifically about the job description, which is the duties of a specific role. It's those clear communication of expectations, requirements, and requirements can be used with regards to the classification. It can also, we have seen some organizations, actually several organizations, review requirements through the lens of equity and perhaps look at education and experience requirements that in the past had been very, very stringent. You know, you must have this degree and you have to have 10 years of experience. And for jobs that don't require a specific degree, they'll use experience in placement of that. But it's clear expectations around what the job is responsible to do, helps you with recruitment and hiring, certainly helps you with performance management, because if somebody's not clear on what their job duties are, how can you expect them to perform? And then it will help you map to salary benchmarks. But again, you can't just go look at the job title and benchmark a salary against a job title, because a program manager at one organization may be very different than a program manager at an organization. You might have a program manager that manages a program but doesn't have any direct reports, whereas a program manager at another organization may manage all the people that deliver the program, so has direct reports. It can be very, very different, and it's going to give you not accurate information in finding an appropriate benchmark. Lori, I don't know if you want to add anything to the importance of a job description.
Yeah, well, I think we've said that it's crucial. I'm gonna add a somewhat humorous anecdote. I as you're sitting here talking about all this, I'm thinking about dating on the apps, right? And the importance of transparency, right? So if you get two people on the apps and one just says, person seeking whatever and just has their picture and no information. And the other person really is thoughtful about providing, these are my interests, these are my strengths, this is what I'm looking for. That helps facilitate finding the right partner more quickly. And look, relationships are relationships, whether we're talking romantic or workplace. To me, I've never understood why employers don't want to be transparent, or an employee doesn't want to be transparent when they're determining whether they're the right fit for each other. Because if your Bumble profile as an employer says one thing and somebody gets there and they've been catfished, that's going to be a disaster for everybody. So I sort of, that was the analogy I was thinking of as you were talking, but I really, the importance of accuracy and transparency, just, let's be honest, it's probably a pain in the ass to do this now, but in the long run, it will be so worth it to do it right.
And I think that's the point is, yes, if you aren't there today and you do need to do these updates, it may feel like a monumental task. But the good news is once you do this, yes, it's a project. Yes, it could be it can be an ongoing effort, but an intentional effort to update over the course of a year. But once it's done, then you're just updating. But in order to get to that place, you want to start from a place where you've really thought everything through. And you also, in light of what's happening with FLSA, we want to look at the duties test too, so that when you do these evaluations of job, you do a job analysis or you do a job description, you can see if a job really, really meets exempt status or not. You have to be honest with yourself about that. So these are just some kind of reminders about do's and don'ts. And I'm not going to cover all of these. Some of these you probably already know, but conduct a thorough job analysis. Now, sometimes HR is the facilitator of that, but HR may not know what all these jobs do. So you really have to engage the supervisors or managers of the roles that oversee these jobs to make sure, and even the individuals in the job, to make sure that you are doing a thorough analysis to determine what the core functions of the job are meant to do. One of the things we hear often, and we see this in the comp work that we do, when we get job descriptions, it can look like they were pulled from a lot of different sites with a lot of different formats and a lot of different information, but really no consistency. And if we know anything in HR, being consistent is a good thing to be able to say about how your descriptions and your policies are structured. So making sure that the standards are included on all of your job descriptions, the job title, the summary, what are the responsibilities, what are the scope of authority, what are the qualifications for the job, and then and it's not on here, what's the physical work environment? And that's going to help you when you have to determine decisions around accommodations. It'll help inform, what somebody can do with an accommodation. You certainly want to include the essential job functions. I will tell you, I have seen job descriptions that are like 4 pages long, and it is a list of every single task that somebody would do, including, well, we don't stuff envelopes anymore, but stuffing envelopes, if that were a thing, when that was a thing. That's not what this is about. Where do you think about bucketing the essential functions of the job in, those 20% of the time, 25% of the time, 50% of the time, 60% of the time, they're focused on these things, but really being clear about what those essential functions of the job. Highlight qualifications and experience. I have an asterisk here because, again, this is something that employers are looking at in a way to remove any obstacles to marginalized communities that may not have access to certain education, or individuals whose work experience really fulfills what could potentially be an education requirement. That said, there are roles within your organizations that require certain levels of education. And we know from the duties test, the professional classification requires licensure and certification and certain educational requirements. So just rethink about that. Make sure that what you are putting in there for experience and qualifications really gives you what you're looking for and is reasonable and is going to help you identify a good candidate. Something that we often don't see in a job description too, and this is important because we know that today's job seekers are curious about company culture, but how does that company culture show through the job description? Are the values, are the core values on there? Is the work environment, do they describe the work environment consistent to the way the culture you're trying to deliver? And again, that can help you attract candidates. We do ask you to think about language, gender neutral language. You can think about ways to be more inclusive, both in your job postings and your job descriptions. And then seeking input from relevant stakeholders. HR, this is not your job alone. So please make sure you pull together the appropriate group of hiring managers, provide them with a framework to help them organize their thoughts. That's something we do. We have a framework for job analysis and for crafting job descriptions. But you have to give someone who's not used to doing that some sort of a framework within which to work. The other piece is update regularly. We see some organizations, anytime a job opens up, part of the process before they can post that job is to update the job description. And that's great. However, if you have people that have been in roles for really, really long times and those roles just don't turn over like other roles, there may be a missed opportunity if you're not regularly reviewing those jobs, updating those duties. Because as we said earlier, those jobs can morph, they can grow, they can expand. And you want to make sure that they're accurately reflecting the work that's being done. Lori, anything that you want to add to the do's?
No, I mean, I think this is a great list. And I do think that your point that I think we tend to think like, oh, HR should sit in an office and do this, but that's not going to be effective. It's really a partnered project, I think.
Mm-hmm. And the list of don'ts here, you may know these: avoid jargon, clear language. Some of our organizations have so many acronyms, but remember, somebody's reading this for the first time, they may not be familiar with your jargon. Don't exaggerate or misrepresent, and avoid discrimination with language or any sort of bias, discriminatory factors such as race, gender, disability. We talked about not overloading with unnecessary details. Don't skip the company branding. Make sure that it's there. Keep it clean, and don't forget the feedback. That's important. Get feedback. Once you draft these, put them out for people to take a look at. In the spirit of transparency, it's helpful to have multiple eyes look at a document before it becomes the document. That doesn't mean that they're going to give you feedback that you can choose to disagree with, but in the world of transparency, it's not that everything is an open book. People are craving transparency about the process you use to develop the job descriptions or to determine salaries. They want more clarity to the process that's being used. And that's how we like to think about transparency.
I don't know why you wouldn't have the person who's doing the job review the job description and sign off on it before you finalize it, because
Yeah.
they're the ones that know what they're doing.
They know what
Right?
they're doing, and you can actually learn quite a bit about it too, because there might be things you're not realizing that they're doing that need to be added in. So just to wrap that up, just make sure you take a look at it. Again, it can feel monumental, but you want to make sure that you are doing it on, just make it part of the regular routine.
Yep.
Update your anti-harassment policies. Lori, you talked a bit about this, and you gave some language. And the other thing that you mentioned that I want to reiterate, the EEOC website is full of resources that are really, really helpful for employees, including sample language, including some of the things that you may need to include. So
Yep.
you certainly want to connect with your legal representative, but also know that there are resources there. You're not starting from a place of no support at all. And certainly at Exude, we can help with that as well. But you want to make sure that everything is reflecting these recent changes and that your policies are up to date. And once they're up to date, they need to be reintroduced and re-implemented so that people are really clear. I have said this before on our previous webinars and in many of the recent seminars that we've done. This year in particular, it's really going to be important that people are familiar with your anti-harassment policies. We're in an election year. We know that there's tension. There's going to be a lot of conversations that people hear externally that are going to filter into the workplace. So just level setting and resetting expectations around what your policies are. How do you report incidents or issues? How do you ensure that people's concerns will be heard and that your investigatory process will be followed? When we talk about training, just as important as it is to have the policy, you have to be able to train people on how to apply the policy. What does it look like? You know, we always recommend that you introduce a policy, whether it's a new policy or an existing policy around anti-harassment, annually. You can review it. Many of the schools we work with do it at the beginning of the school year, but organizations can do it at the beginning of their fiscal year or at a certain time every year, just to remind people of everyone's responsibility in adhering or applying the policy, living the policy. Educating managers on their responsibilities. This is important. Managers need to know that they have a duty to respond in one way, shape, or form. That response may be notifying human resources, but if they do or are aware or somebody does come to them with some sort of a concern or an issue, that they just can't say, oh, that's just Lori, she always does that. That's not an appropriate response. And then you're going to end up with Lori, and Lori, I don't know if you can share any stories about how someone had the best policy in place, but their managers didn't execute effectively, and therefore it rose to the level of.
I had a jury trial here in Philadelphia. I know we're running just a minute over, so I'll make this quick, but I had a federal jury trial involving harassment retaliation claims where the company had a policy, had a procedure, had a handbook, had postings. I had done the training 6 months prior, and one of the supervisors, and I'm going to tell you flat out, although they did all that, that was one of those, we taught the talk, but we don't walk the walk. Like it was lip service. So even though they had all those things, they weren't really buying it. But I had a manager who walked through the work area and saw signs that were inappropriate, signs you would have seen at Spencer Gifts or whatever, right? Clearly not appropriate for the workplace. And acknowledge on the stand, oh yeah, we had a policy. Yeah, we had a procedure. Did you have training? I don't remember. I'm like, I did the training. I know you were there, right? And did you see these signs? Yeah. Do you think they're a violation of your company's policy? Yeah, but they didn't really bother me. So did you manager, did you do anything about them? No, I just ignored them. So it is more than just sort of mailing it in. If you really want to affect change, it's really, really important.
Yeah, and those are real stories. So we know managers may have best intentions, but if they're not educated and not reminded on a regular basis, think about doing in-person training. And if it's not for all staff, certainly for managers, so they can allow for that situational discussion, create that safe space for them to ask questions that they have around the gray areas. Same with staff when you can, because the gray areas is where the problems often arise. And then make sure you review that reporting incident process so people know that they should have, if they don't, there's an option. They don't have to go to their immediate supervisor. They can go to someone else. Those are the things that are going to put you in a better defensible position if indeed a claim is made.
I have to say that the minimum, I don't think people, now that jury trial that I referenced was probably 6 years ago now. I think post Me Too, I think with today's workforce, the intolerance, and I mean that in a good way, of younger workers to put up with stuff that some of us who are of an older generation sort of dealt with and probably wrongly sloughed off. Just mailing it in is not going to be sufficient if you're in front of a jury at this point. You have to show that you really mean it. You really took effort to create the right place, the right sort of respectful workplace.
Mm-hmm. The other thing that's not on here is you also always want to review what retaliation means, and that people should not fear retaliation, that you have a policy of no tolerance for retaliation, and then help managers understand what retaliation could mean, so that they don't inadvertently take an action that could be considered retaliatory.
So I guess,
So-
Alison, we should wrap up with our key takeaways.
Yeah. Wait, so invest the time. I know it's time, but review the job design, update job descriptions, look at those anti-harassment policies, conduct training, and then non-competes. Lori, you want to speak just briefly to that? Just review and update.
Again, call your legal provider or professional. If you don't have one, call me. If I can help you, I will, or I'll help you find somebody who will. And ask yourself, why do we want one? What is it we're trying to protect? What's the best way to accomplish that? And make sure that you're prepared in case there really is things that you need to be thoughtful about. You don't want to be caught in an unenforceable situation. So
great. Well, everyone, we know that there was a lot going on there today, and we thank you for staying with us. And we did go a little bit over. Apologies for that, but a recording will be sent out for those who weren't able to attend today. So please share that as you see fit. Lori, thank you again for once again shedding light on what's happening and what employers can do. If you haven't had time to have your questions answered, please feel free to reach out to either one of us, and we'd be happy to talk with you offline.
Absolutely.
Everybody at Exude and at Fox Rothschild, thank you again for joining the Morning Blend. We hope to see you the next time.
All right. Have a great week.